It's often called the death penalty of employment law. Termination for cause involves ending an employment relationship without providing any severance. What you may not realize is that most for-cause terminations are not legitimate. In this episode of the Employment Law Minute, we explore the common misconceptions around terminations for cause, what it actually means, and when it can be used legitimately. Welcome to the Employment Law Minute, where we talk about common workplace issues and explore practical solutions for both employers and employees. I'm your host, John Scholes, and I'm joined by Ottawa employment lawyer Alex Lucifero, partner at Samfiru Tumarkin LLP. Alex, right down to it. What does it mean if you're terminated for cause? What does that mean?
So in the ordinary course of letting an employee go, John, of termination of employment, an employee is going to be owed severance. They're going to be terminated without cause, meaning that they're owed severance, most likely based on their age, their position, and their years of service. A termination for cause occurs when an employee does something so fundamentally terrible, so contrary to the employment relationship, that the employer is allowed to let that employee go without any kind of severance, without any notice, no pay whatsoever. You know, you're walked out that day for cause. You don't get anything besides your last day of work. Now, those situations, John, legitimately speaking, are few and far between. Oftentimes, employers will jump the gun. They'll terminate for cause where they haven't met that threshold yet. Right. And that's a problem for employees. They're going to be those employees are going to be owed severance, even if they're purportedly terminated for cause. And not only that, but employers can be penalized even beyond just severance for treating their employees that way. So it's a very problematic situation for an employee when they're letting an employee for cause. They have to make sure that they actually meet the threshold for cause, which is very, very difficult to do. You mentioned it yourself in the intro. It's the capital punishment of the employment law relationship, or the death penalty of the employment law relationship. It's reserved for the most serious of cases.
So what would be some legitimate causes for termination of cause? What would they be?
Sure. I mean, you and I could probably think of a couple of obvious examples. So stealing from your employer is one of them, right? There's absolutely zero tolerance in the workplace for theft. If an employee is caught for theft and an investigation is conducted and it's proved that you stole, guess what? You're going to be terminated for cause, and rightfully so. Other things could include misconduct, physical violence in the workplace, completely uncalled for, termination for cause. Even something like verbal abuse or verbal violence, if it's something that an employer has tried to correct, but the employee continues to act completely inappropriately in the workplace after a number of warnings, that could be a termination for cause. Performance is a little more difficult. It's very, very tough, John, for an employer to terminate an employee for cause for performance issues. But even in situations like that, if it's sustained poor performance, after attempts at rectifying the situation, after attempts on the part of the employer to help improve the employee's performance, if the employee is not responding, cause becomes a potential option. Again, as an employer, you want to make sure you're not jumping the gun. It happens all too often.
In many cases, as far as employees are concerned, they've been disciplined or they've been put on a performance improvement plan. What can that employee do if they feel they're being, set up for termination of cause?
It does happen more often than we think. Employers will try and build a case against an employee, try and warn them once, warn them twice. Sometimes those warnings aren't even warranted. And what you want to do as an employee in that situation is you want to make sure that you're responding in the moment. So if you are given a verbal reprimand, or if you are given a written reprimand, you want to, rather than just sign off or accept whatever reprimand that is, you want to respond in writing and actually put your version of events, your record of events, on the table as a formal response. That could be in an email format. It can be by way of a written letter. It doesn't have to be overly complicated, but you want to make sure that you're responding in writing and that you put forward your version of events, because you could be looking at that situation, John, a month later, 2 months later, or 3 months later, and you want to be able to rely on that record that you've created in support of your position that this was not a cause termination, that this was a without cause termination. The other thing I'd recommend to employees in that situation is you need to get employment advice. I would encourage them to contact us. We can talk about it, we could brainstorm, we could come up with options and solutions for employees in that situations. And for employers as well, you want to get advice before you terminate for cause, and I would encourage employers to contact us if they're if they're looking at terminating an employee for those reasons.
All good stuff, Alex. We're going to leave it there for now. Are you experiencing an issue in the workplace? Contact us now, help@employmentlawminute.ca or 1-855-821-5900. Go to employmentlawminute.ca. You'll find past episodes of the show, resources for employers and employees, as well as contact information to help you find practical solutions to workplace problems. employmentlawminute.ca. Thank you for watching. We'll catch you next time.